Welcome back, everyone. This is the second part of class number 11, and we're talking about secure transactions today. So I'm going to go ahead and share my screen, and we'll look at the first of two essays.
If we're only doing one, let's do the 2021.
Okay.
If we're
Well,
doing both, then it's fine.
yeah, we'll do both. We'll do both, and we'll try to
2021 is like better.
we'll get through them both expeditiously because they're not so hard. Do you know what number it was for 2019?
It was three or it was this one, two.
Two, yeah. All right, bet. I'll read this one. A company is in the business of manufacturing and selling stereo equipment. Let's see the cause of the question. Does the company have any claim against bank with respect to the sale of gramophone? As between the bank and the judgment creditor, who had a superior claim to the gramophone? And does the bank have an enforceable security interest in any personal property of the company other than the gramophone? Explain.
It's very gramophone heavy.
Yeah, I have no idea.
It's like an old music device.
That's what I thought it was. It looks exactly as I imagined. All right,
Yeah.
Okay. A company is in the business of manufacturing and selling stereo equipment. Several months ago, the company borrowed money from a bank to be repaid by the company in monthly installments. The loan agreement, which was signed by the company's owner, provided that to secure the company's obligation to repay the loan, the company granted the bank a security interest in all personal property owned by the company. Also that day, under an oral agreement with the company's owner, who had full authority to speak on behalf of the company, the bank took possession of one of the most valuable items of the company's property, an original Edison gramophone that the company had acquired because it was the earliest precursor of the company's digital music players. So they made a loan and they granted the bank a security in all personal property owned by the company, and they took possession of the gramophone. The bank properly filed a financing statement in the appropriate filing office, listing the company as debtor, and in the space for indication of collateral, listing only all personal property. Since borrowing the money, the company has run into various financial troubles. It has missed some loan payments to the bank and recently lost a lawsuit, resulting in large judgment against the company. Last month, the judgment creditor obtained a judicial lien on the gramophone. Last week, the bank notified the company that was in default under the loan agreement. Without giving advance notice to the company, the bank sold the gramophone to an antiques collector in a commercially reasonable manner. The judgment creditors learned about the sale of the gramophone and asserts that a superior claim to it. The sale of the gramophone did not generate enough money to satisfy the company's obligation to the bank. The bank would like to seize some of the company's other property in which the bank has enforceable security interests. Here's the three questions for discussion. Does the company have any claim against the bank with respect to the sale of the gramophone? So let's look at that one. The company versus the bank. I mean, the bank, they notified the company was in default, and then without giving notice, they sold the gramophone to an antiques collector in a commercially reasonable manner. I kind of have a problem with that, right? They didn't give them notice.
Yeah, because it needs to be notice of like a public sale. So the person, if they somehow are able to get the money, they can do the equivalent of redemption. Like they can basically get their stuff back.
We're all saying the notice part is no good here. And so what other pieces would you mention in this explanation?
I mean, commercially reasonable. That's good for the bank. So the company would not have anything for that, and there's no breach of the peace. But the notice requirement wasn't really met.
Right, and Paul's saying a right to secure.
Do you think we'd probably talk about like the legitimacy of the security interest and the perfection here in this question?
Yeah, sure. You'd see, does the bank have,
If it goes to the second question, you can just copy and paste. That's what I did.
and are they a PMM? Are they a PMSI? We'll look at that. They're not a PMSI.
The gramophone is very old. They purchased it a long time ago.
Okay. As between the bank and the judgment creditor, who has a superior claim to the gramophone? So this is going to be priority, financing statement, and things like that.
Yeah.
So typically, first to file will be first and right. They did file a financing statement. Was it legitimate? I think there's a definite conversation here about all personal property and all personal property, and that being generic and super generic.
It is very generic.
Mm-hmm.
It's not like if it was all property, we would know what that meant because it meant everything. All personal property, what exactly is that? It's not really
right. So that's the problem here is they did file a financing statement. It should be first in time, first and right, but it just said all personal property. Is that enough? to include the gramophone, but it did say that they took possession of it. And so I think it would be automatic. And I think taking possession is going to defeat any claim. So I do think that by taking possession, the bank has superior claim. That would be my argument. Is right here, the bank probably needed to provide notice. And right here, the bank probably has superior judgment because they took possession, and that should be enough to put the world on notice. The counter argument is that they weren't on notice because it just said all personal property. What are you gonna say, Brayden?
No, that's what I was gonna say.
All right. Does the bank have an enforceable security interest in any personal property of the company other than the gramophone? Does the bank having security interest in any personal property of the bank other than the gramophone? Probably not, because of the genericness of it, and they didn't. You agree, Matt?
Yeah.
Is that it? We're cut and dry. We just cruise through this.
Were they detailed in the security agreement, or no? It was just that also said all personal property.
It said also personal property in the security agreement and in the financing statement.
Oh.
I mean, if I were, hopefully we're right, because then we could just move to the second question. But I think that the company does have a valid claim because they didn't give them notice. I think the bank defeats the judgment creditor because they took possession, which will satisfy a financing statement. And I think the answer is probably no, because it was too generic. And what does other personal property even mean? There's definitely counter arguments to all three of them, but I think those would be the prevailing arguments just by first glance. What are you gonna say, Brian?
Yeah.
You agree, Matt? Disagree? Have any thoughts?
No, I agree with everything that you said.
Literally. All right.
I don't think secure transactions questions are that deep.
Nah, me neither.
That's something you would have said in the other video.
I made a name for myself in Florida by teaching secure transactions and commercial paper, because everyone was so scared of those subjects. I'm like, I promise you, they're the easiest subjects. They just moved them in Florida to
Commercial paper, I don't know.
What'd you say?
I don't know commercial paper because we don't study that.
Oh, I love commercial. No, I'm just kidding. But like, it literally is my. They changed it from essay to multiple choice, but as a multiple choice, it was like the easiest thing. If you could just memorize like this one little sentence and just recite it, then you could crush any commercial paper essay.
Long answer. Okay.
All right. The company has a good claim against the bank with respect to the sale of the gramophone is where they observe the proper sales procedure, enforcing that security interest. The preliminary question is where the bank can enforceable security interest over the gramophone is dealt with in part 2 of the answer below.
Right, yeah, that's what I was thinking. Like, where do we put this answer? But just put it somewhere. As long as it's somewhere, they find it.
As a general rule under Article 9 UCC, a secured party is entitled to enforce its security interest over personal property if the debtor is in default or under the relevant security agreement. Enforcement may take place by a variety of means, including repossession, self-help, strict foreclosure by exercising the power of sale. So I guess foreclosure terminology does come up here, but it's not that common. In order to correctly exercise the power of sale, the secured party must conduct the sale process in a commercially reasonable manner, like we stated, and give reasonable prior notice of the sale to the debtor, any guarantors of the debtor, and in case of non-consumer transactions, any other secured party or claimants against the party of whom the prospective enforcing secured party is notice. If the sale procedures are not correctly followed, the debtor may claim its actual damages against the secured party, and the secured party may also be precluded from recovering any deficiency judgment that may apply. Here, the bank elected to sell the gramophone to an antiques collector in a commercially reasonable manner after notifying the company that was in default under the loan agreement. On its face, it appears to satisfy it. However, it's not, because there's no notice. When the bank noticed it of the default, it did not notify of the sale. Therefore, the company and the judgment creditor were not afforded the rights in Article 9, and the bank has a breach of Article 9 obligations. On the basis of this breach, the company may be able to seek monetary damages from the bank. Given that the sale is at a good price, probably the main source of damage it can claim would be its lost profits or on some indirect measure of damages. In any event, however, the bank may be able to seek relief from any deficiency claims by the bank on the basis that it's forfeit these claims by its breach of Article 9 power of sale process. So we nailed that. No notice. Now the bank has a superior claim. The key issue here is whether the bank had a valid enforceable security interest over the gramophone, and where the bank's security interest would take priority over the judgment creditor's security interest. On the first issue, a secured party can enforce security interest as attached and has been properly perfected. In order for attachment to occur, 3 things are required: valid security interest, which describes the collateral and evidences the intent to grant security over it, which may be oral in relation to personal property. The debtor must have the present right to convey the interest in the relevant collateral, and the secured party must give value in exchange for the security interest. Perfection then can occur by filing, possession, or control. Physical possession of collateral is an acceptable form of perfection for tangible goods, including inventory and equipment. Here, all three elements of attachment are most likely present in respect to the gramophone. Firstly, although the facts may be open to dispute, there's likely a valid security interest which describes the collateral evidence of the intent to grant security over it. While the written loan agreement is probably not sufficient on its own because it's super generic, like we said, the subsequent oral agreement to take them probably was enough to create security interest. It created pledges, as I would say. On the second element, the gramophone is described as being one of the most valuable items of the company's property and is therefore safe to assume that they owned it, therefore, and had a right to convey it. Third, the bank gave values. This is the whole pig analysis.
Yeah.
Here, most likely sufficient contemporaneity between the giving of value and giving of security because they occurred on the same day and as part of a single transaction. Accordingly, there was security interest. Here, perfection are also met. The gramophone's equipment or inventory, it clearly fails into tangible property. A security interest can be therefore perfected by possession. This is what occurred. Accordingly, the bank had valid enforceable securities over the gramophone. On the second issue, as a general under Article 9, prior perfected security interest will take priority. The gramophone was
First in time, first in right.
exactly first in time, first in right. The bank security interest takes priority. We were 2 for 2. We're an incredible team. Although it is a close call, depending on the construction of the security agreement, the better answer is that the bank does not have an enforceable security interest in any other personal property. That's what we said. The key issue is here whether the description of the bank security was stated with sufficient particularity to cause it to be validly attached. We definitely said this perfectly. As a general rule under Article 9,
Just like repeat the same stuff as before.
yeah, repeated. While super generic descriptions such as all that assets of debtor may suffice for purposes of the financing statement to be filed for perfection purposes, something more detailed is required to be inserted in the security agreement itself. Matt literally said this in his outline, that it's okay for the financing statement, but the security agreement itself needs to be a little bit more detailed. Here, it's super generic to say all personal property, you know, argument both ways, but like we said, probably super generic. The other person pretty much seemed to agree that they do have a claim because they didn't provide notice. This is very, they usually have to give 10 days before.
I appreciate the brevity.
Me too. I appreciate the brevity, but honestly, in a month from today or whatever it is, when I'm in Philly, I'm not writing brief answers. I'm taking every second to write as much as possible because I'd rather try to get my points than miss them. But I do appreciate the brevity here. So yeah, first in time, first in right. So we said the bank has a superior claim, and then the last issue was it's too super generic. They do not have a enforceable security interest because it didn't lack in the specificity of here and after acquired later creditors. Did not have specificity to put people on notice.
Yeah.
Right? Not a valid description of collateral. All right, that one was super duper triple easy. I mean, I don't want to like say that if other people watching this didn't think it was easy, but if you watch the lecture that Matt and I just did and then do that essay, it doesn't get any easier than that. Let's try this one.
Maybe the next essay you learn that it actually does get easier.
Oh, nice. I was just gonna say, I was like, we're gonna try to see. So, okay, I've learned one thing. I'm praying for secure transactions on my test.
No, I remember like doing this as a practice test like last year before my bar, and I was like, this is the easiest question I've ever seen.
It's got to be question number 4, right?
Yeah.
All right. Which of the banks, if any, have enforceable security interest in the key manufacturing machine? Which banks, if any, have perfected security interest in the key manufacturing machine? Enforceable security interest versus perfected security. I think that's the same question twice. Yeah. So one is who has security interest, one is perfected. And what is the order of priority of the enforceable security interest and supplier's lien on the key manufacturing machine? So priority, easy. Security interest, perfection, priority. Ding, ding, bang. Yeah, like the 3 main tenets of secure transactions. Let's check it out.
The other question was basically on this too, except with an added like repossession question.
Keyco, a company that manufactures keys, oh, what a really, really clever and unique name, has had significant cash flow problems as a result of market trends away from keys and towards electronic. Never thought about that. The key industry got murdered by the electronic lock industry.
Yeah. Oh, I actually use a key because my building's very old. But my friends just use their phones for their building.
Interesting. That's got to adjust. Nothing's coming for us, Matt, because we're 7 steps ahead. Accordingly, last year, Keyco borrowed money on 3 occasions. On February 1st, Keyco borrowed $200 from First Bank. Pursuant to an agreement signed by both parties, Kiko promised to repay the loan within 2 years and grant First Bank a security interest in all of Kiko's assets. Again, pretty generic, to secure its repayment obligation. On the same day, First Bank filed a property financing statement in the appropriate filing office, listing Kiko as a debtor and indicating the declares all of Kiko's assets. Again, we have a problem with the super generic in the security agreement. But they did complete a financing statement. On Kiko, on the first, they borrowed $400,000. They must have had really good credit to be able to borrow all this money from Second Bank. Pursuant to an agreement signed by both parties, they promised to repay the loan within 4 years and grant security interest in all of Kiko's equipment to secure its repayment obligation. Okay, so this is equipment. It's a little bit more specific, and this is second in time on Second Bank. I'm so happy they called it First, Second, and Third Bank. That's amazing.
Yeah,
Florida would never do that. Florida would call like the first one Second Bank and the second one Third. I swear.
And then the Third Bank would be like Fifth Bank.
Right. On June 5th, Kiko borrowed $600 from Third Bank. Pursuant to an agreement signed by both parties, Kiko promised to pay all loan within 6 years and grant Third Bank a security interest in all Kiko's equipment to secure its repayment obligation. At the time of the transaction, they knew about this. So Third Bank, I mean, they had notice. They don't tell us whether they knew about this one. On August 1st,
No, it says Third Bank knew about First and Second Bank, but it doesn't say if Second Bank knew about First Bank.
exactly. It doesn't say that. So on August 1st, Third Bank filed a properly completed financing statement in the appropriate financing office, listing Kiko as a debtor and indicating the collateral is all of Kiko's equipment. Okay, so they did a financing statement. Did Second do a financing statement?
Doesn't say.
No, they didn't do a financing statement. Idiots. On October 1st, supplier obtained a judgment against Kiko for unpaid debt, and in connection with that judgment, obtained a lien on their key manufacturing machine. The key manufacturing machine. So that seems like definitely equipment, right?
Yeah, because it's not inventory. It could be. It's probably not farm equipment, and it's not consumer goods.
Right. The difference between inventory and equipment is inventory is in stock, equipment's in use. So it's in use.
Yeah. Exactly. It's not being sold or like used,
So,
or it's not being sold or like used. It's not raw materials. Raw materials are used, but like they're also inventory. But like a computer that you use, like that's just equipment. It's not being used up, is what I'm trying to get at.
right. Except as described above, no financing statements have been filed that list Kiko as a debtor.
So First Bank and Third Bank did financial filing statements, right?
But not Second Bank, yeah. But
No.
First Bank was very generic in their all of Kiko's assets.
I
So
wouldn't expect
honestly,
anything less of Second Bank.
Third Bank might sneak in for the win here, just based on them being proper. But the problem is they had notice. That's the only thing I don't like about Third Bank. They had a lot of notice. So which banks, if any, have enforceable security interest in the key manufacturing machine? Explain. So let's go 1, 2, and 3. Does one have a security interest in the machine? Probably not, I would argue, because all of Kiko's assets is too generic. Does number 2 all of Kiko's equipment? Probably yes, I would argue, because I would say yes. Braden's on the fence, but I just feel like it's identifiable. I mean, their equipment.
It's generic, but it's not super generic.
I think maybe
If
yes.
there's like
And then this, all of Seco's equipment, yeah. So I would say 2 and 3 probably have security interest, but not 1.
Yeah.
Banks, if any, have perfected security interest in the key manufacturing machine. Explain. So who has a perfected security interest?
well,
does,
one and First and Third.
well, let's see. Does one?
But
Yes, but it says in the machine, again, 1 is questionable because they do have a security interest, but it says all of their equipment. But did they ever actually have an attachment?
so I would think like First has the financial filing, but it doesn't perfect until they attach, and they haven't attached.
So I don't think they perfected yet, to be honest.
Third filed, and then they perfected later.
In my opinion, 1 hasn't perfected yet. Has 2 perfected? They literally don't even give never perfected. Has 3 perfected?
Yep.
It says they perfected. They knew about these transactions. That's the only thing. They're not
It matters though.
no. What do we call that? A bona fide purchaser in security transactions?
Yeah, I don't think that's only for like. That's a different way of getting out of the security interest. Like here, that's not really the case because because they're going against the others in priority.
Right. So if you were gonna ask me,
Also because of creditors, like bona fide purchaser, that's about like debtors getting it without the security interest.
Yeah, but what's it called though? A
Buyer in the ordinary course of business.
buyer in the ordinary course of business. Yeah.
I don't.
They're
Yeah,
not-
I don't think that really applies
I
here.
could just throw that in. Like they're not. Oh, but yeah, you're right. That's about like buying something. That's
Yeah,
not about.
these are creditors.
These are creditors. So, in my opinion, and I could be wrong, I would say only 3 has a perfected security interest. 1, they never attached. 2, never even tried, and 3, they have perfected.
Yeah.
Has anyone had control over it? It doesn't seem like it. No, I don't think so. All right, and then what is the order of priority, the enforceable security interest, and suppliers lien on the key manufacturing machine? I mean, if we're correct, perfected, first to perfect wins, and then if we're correct, first to attach versus unattached wins. If we're correct, I would say it actually goes 3, 2, 1.
Yeah, but also you have to bring in the supplier.
Oh, who's the supplier? Sorry.
So,
Supplier.
the supplier was October.
Oh, so supplier. So he has a lien. So I think it goes third is first, then the supplier, then second, then 1. That's what I would say. 3 supplier, 2, 1. That'd be my argument. What other?
Supplier 2-1.
I said 3
Yeah.
supplier, 2, 1.
Yeah, I agree.
You agree?
Yeah.
All right, that makes me feel good. If Matt agrees, I feel confident. Anyone disagree with that? I just think 3 is going to win because he's the only perfected one. Then 2 is going to come in and it'll be perfected versus perfected first in time, so he'll be below 3. But he'll actually beat everyone else because no one else is perfected. And then I think
Yeah.
2 will beat 1 because 1 hasn't even attached.
Yeah,
These
this
are
is what's that game.
Let's see what the final answer says. These are my arguments, but I'm not sure if it's the strongest argument. But again, a good answer. Like I've never seen this question before, but I think I would have gotten a good score even if I'm wrong, because at least I could talk about what attachment means, what perfection means, what priority means, and I have a strong argument. I'll see if I'm right or not. It was 3, I think.
Yeah.
All right.
No,
No.
it was 4.
4. Second, third have enforceable security interest, and first bank does not. That's what we said. The issue is whether the description is valid and it has to have extends value. The debtor has interest in the collateral, and the security interest evidenced by the debtor's authentication of the security agreement, possession or control of collateral. The security agreement can describe the collateral by classification, but cannot be super general, all assets. Here, the banks extended value because they loaned money to Kiko. Kiko had interest in assets, including equipment. And all 3 banks made a security agreement with Kiko by a writing signed by both parties. Furthermore, second bank and third bank appropriately describe the collateral by classification, Kiko's equipment. However, first bank described the collateral in a super general way, all of Kiko's assets. Thus, first bank security agreement is invalid. The key manufacturing machine and equipment is good because it's a good that is not consumer good, farm proper inventory. Therefore, second, third have enforceable security liens in key manufacturing machine. First bank does not. The issue is how to perfect the security interest. A secured party may establish security interest against other secured parties by perfection. A secured party may perfect his security interest by filing a financing statement with the Secretary of State or obtaining possession or control of the collateral. The financing statement must describe the names and address of the secured party and debtor in the collateral. Here stated above, first bank filed a financing statement, but security interest is not enforceable. Thus, the security interest is not perfected. Nailed it. On August 1st, third bank filed a properly completed financing statement that said all the equipment, it was perfected. Second bank never did it, therefore it's not perfected. So we crushed that question.
Yeah, like there are no twists here.
No twist. I love this.
I thought like this is a very simple question. Like this is like it's not even like a test question. Like this is like a practice question used to just like understand the basics.
And the problem is when I first started doing UBE essays, I worked with Brighton, and we got hit with a couple of trick questions right off the bat. And so I was like, wait a minute,
not here.
super tricky. But as I've done more essays, it's not that tricky. There's just a couple things where it's like, all right, they were getting at a little niche rule that they like to test. They like to test some little niche rules, but overall, it's not that tricky.
Like don't quote me on this, or you can quote me, but don't bet money on this. But like I feel like they tend to do less often the niche rules for the MEE topics.
Right, exactly. Generally, a perfected security interest has priority over an unperfected security interest. Between 2 perfected security interests, the first to file perfect wins. A judgment lien has priority over conflicting security interests only if the lien was obtained before the conflicting interest is perfected. We crush this. Here, third bank wins, supplier is second did not perfect, unenforceable. Therefore, they have priority in the following order. Third, supplier, second, first. I'm so proud of myself.
Yeah.
No, I'm just kidding, but like we crushed it. So the same answer right here, they said that right, there's security interest, but the problem is second and third bank. I mean, the problem is for first bank, it was super generic when he said all assets, but all inventory was okay. So long answer short, second and third will have security interest, not first, because it was super generic. The perfection, like we said, first couldn't perfect because it never secured. Second never even tried to perfect, but third properly acquired and did file a financing statement. Therefore, third is the only bank with perfected. And then priority, we're totally correct. The interest is going to go third bank has first priority because it was perfected the interest. And then supplier has second because it obtained the lien. Second bank has third because they at least attached. And then first bank has nothing, literally nothing. So I'm going to be honest, of all the subjects we've done so far for the UBE, secure transaction has been the most straightforward in terms of the essays. It's just like material, you can crush the essays. It's not trying to trick you at all. That makes me feel really good. Not that I think the UBE is incredibly difficult, but I think that at least a subject like secure transactions, which is a little bit weird and notorious, at least it's straightforward.
Yeah, it's like middle of the road in terms of like how often it comes up. Like it'll definitely come up more than family law, but like less often than like agency or corporations. So I would definitely like, it's really also like not that hard to learn.
No, I feel like
know your attachment, know your perfection, know your priority, and like you're really good to go. Like move on to something else.
the one rule that, I mean, I always say that they like to test things. They definitely like to test the fact that attachment, we cannot use super generic. Perfection, we most likely can. That's just a thing that I've seen. But yeah, I think today was a great class. I learned a lot and I feel solid about secure transactions. Tomorrow's going to be super important because we're going to do the MPT. That's going to be Matt, you know, that's what he gets paid the big bucks for. I'm going to sit back and relax and learn how to write amazing MPT essays. So looking forward to doing that tomorrow.